Vitiated.
Without objection.
Thank you. I rise today to speak for the second time about this Supreme Court vacancy. And I do so not callously, not spontaneously, but really after 23 years of service on the committee. So I like to believe I have some experience and some knowledge about how these matters have been handled in the past. And, Madam President, I truly believe we have an obligation to consider a president's judicial nominees no matter when. And I'd like to speak about why that duty is so important, particularly for the Supreme Court, and the consequences of not fulfilling it. To be very candid, I'm shocked at the supreme nature of what's happening because of what I believe its impact is going to be in the next year. Since the Judiciary Committee started holding hearings on Supreme Court nominations in 1916, not a single nominee for a vacancy has been denied a hearing, ever. Even during presidential election years, the Senate has done its job. In 1988, President Reagan's final year in office, Senate Democrats confirmed Justice Kennedy. 3 years later, 1991, Justice Thomas was confirmed after the presidential campaign had begun. Democrats could have said no hearing, no committee work, no vote, no consideration by the full Senate. But that didn't happen. The nominations were processed, and they were confirmed. So why is it so important that we do our job? Why is an 8-member court unable to function to the highest and best use of the United States Supreme Court? Ties in the Supreme Court create uncertainty in the law. Important legal questions go unanswered. The law varies then throughout the country, and people and businesses often fail to receive justice. I'd like to review just some of the examples where an incomplete court was unable to levy justice. These are several examples of the importance of 9-member justices if one looks at recusals over the past few years. In 2010, Justice Kagan recused herself from Flores VR v. the United States. This case was going to decide whether a United States citizen father must reside in the United States longer than a United States citizen mother in order to confer citizenship to his child born abroad. The court deadlocked 4-4. The result is a child in one part of the United States may be considered a citizen, while another in the exact same situation in a different judicial circuit may not be a citizen. This issue remains unresolved today. In 2000, Justice O'Connor recused herself from Free v. Abbott Labs. The case should have determined how many plaintiffs in a federal class action suit must meet a certain damage threshold for the case to proceed in federal court. Again, the court deadlocked 4-4. Because the case was left undecided, a later Eighth Circuit, the circuit covering Iowa and other Midwest states, was thrown out. That meant 30,000 individuals claiming damages from a nearby refinery were denied justice in the federal court. This, even though the company admitted releasing lead and other pollutants into the air. The issue was resolved by another Supreme Court case, but it was 5 years later. And that was little consolation to families who didn't receive justice in federal courts in the interim period. 3, in 2007, Chief Justice Roberts recused himself from Warner v. Lambert v. Kent. This case was meant to decide whether individuals can sue for injuries caused by defective pharmaceuticals when the drug maker allegedly hid information from federal regulators. The 4-4 tie in that case failed to clarify the law, which still varies across the country today. Let me give you an example. Plaintiffs in the Sixth Circuit are now unable to sue for personal injury in this situation, while individuals harmed in the same way by the same drug in states covered by the Second Circuit are allowed to do so. In another case, in 2007, New York City Board of Education versus Tom F., Justice Kennedy recused himself. The deadlock court failed to rule on whether special needs children must first attend public school before they receive tuition reimbursements to attend a private school better equipped to help them learn. This meant courts in different states treated these children differently. The issue was eventually resolved 2 years later, 2 vital years of schooling that children may have missed out on. 5, in 1987, before Justice Kennedy took his seat, the court heard U.S. v. Carpenter and Winans. The case, which came in advance of that year's stock market crash, involved defendants convicted of securities fraud based on allegations they misused information from a Wall Street Journal investment advice column. The Supreme Court failed to determine whether the action could be a basis for prosecution. The law was left unclear for 10 years, during which time some lower courts overturned criminal convictions for this sort of fraud. Mr. President, Madam President, these are just a handful of cases that illustrate how an incomplete court can't fulfill its duty and why the Senate must do its job and fairly consider this president's nominee. To leave the Supreme Court in this situation for a year and some months is, in my view, unconscionable. So why is it happening? I actually can't come up with any reason to refuse to review Obama's nominee than politics. The only explanation is that Senate Republicans want to deny this president the ability to fulfill his constitutional obligations. And this isn't the only evidence of such targeted obstruction. It has been a sustained course of action more than a decade now. During the Clinton administration, more than 60 nominees to the federal court were blocked by a Republican Senate. Many weren't even given a hearing. A comparison with the final years of President Bush's term is particularly telling. In the 2 final years of the Bush presidency, the Democratic-controlled Senate confirmed 68 judicial nominees. That included 10 confirmations in September of his final year in office. So 8 months from now, back in the Bush years, the Democrats in control were confirming Bush appointments. So far, over President Obama's final 2 years, Republicans have allowed confirmation votes on only 16 judicial nominees. Think about that. 11 confirmations in President Obama's second to last year versus 10 confirmations just 4 months before President Bush left the White House. The inequality here really, I think, must sink in. People must begin to understand that. The length of the process has also ballooned. Under President Bush, the median number of days between committee and floor votes was 14 days, that's 2 weeks, for circuit court nominees, and 19 days, 3 weeks, for district court nominees. For President Obama, the corresponding length between floor votes for circuit court nominees was 84 days. That's 2.5 months. And for district court nominees, 8 days. So you see immediately the difference between how the sides are handling judicial appointments of a president that may have been in the other party. Most of these nominees were eventually confirmed by unanimous or near unanimous votes. So that shows no need for extended delays. There were no problems with the nominees to deserve extended delays. When President Bush left office, there were 34 vacancies. Now that's a vacancy rate of 3.9%. Today, there are more than 81 judicial vacancies, nearly 10% of all Article III judges. Madam President, Republicans have clearly decided not to do their job, and the American justice system is going to suffer before it. One thing I don't like to do or make anything that can be described as a threat, but I will be candid with you because I don't think I'm a firebrand. I don't think I'm that partisan. But when this is done with the Supreme Court, it signals a whole other level of malevolent obstruction. And one thing I've learned in my 20 years is what goes around comes around. So to do this, to keep this seat vacant for over a year, because it's the fourth year of President Obama's term, makes no sense at all. And as I said, is really unconscionable. So, Madam President, if you don't think an 8-member court is a problem, you really don't need to take my word for it. Let's listen to the justices themselves. Justice Scalia, in deciding not to recuse himself from a case in 2004, said the court would be, quote, unable to resolve the significant legal issue presented by the case. He pointed to the court's own recusal policy, which remains in effect today. It says, and I quote, even one unnecessary recusal limits the court's ability to function. So one can interpret from that by not doing their job, the Republican side of this aisle is certainly limiting the court's ability to function. I'm not sure the other side should want that on their shoulders. I'm not sure what may come up this next year, to the degree to which justice would be denied in a 4-4 court. But justice would certainly be denied, and it's probably going to happen. Judge Rehnquist said in 1972, when he warned that a divided, quote, court would lay down one rule in Athens and another rule in Rome. So here's the conclusion. A president is elected to a 4-year term. Both sides of this aisle know that. But today, Republicans are in effect saying that a Democratic president only gets 3 years of judicial confirmations if a Supreme Court vacancy comes before it. And that's not what the Constitution says. All of us swore to fulfill the Constitution, and I truly hope my Republican colleagues will think about this. Will think about what will happen next year if this president is denied this appointment for the remainder of this year, and a judgeship is certainly delayed way past that point. So I think to deny this goes against both the spirit and the letter of our duties as spelled out in the Constitution of the United States. Once again, I would say, please, Republicans in this House, do your job. Thank you, Madam Chairman, Madam President. I yield the floor.